Hi, I'm Elizabeth Gearhart. I'm here with David Postolski, partner at Gearhart Law, a full-service intellectual property firm with patents, trademarks, and copyrights. Hi, David.
Hi, Elizabeth. I'm so happy to be at Fireside.
Yeah, so tell me, what makes your clients want to work with you, David?
I I've given a lot of thought to that over the years. I think primarily it's because even though I'm a lawyer, I'm also an educator. That's a big thing. I teach at different universities, and I feel like my clients are my students at the end of the day. They're kind of the same thing. I really want our clients and my clients and the people that are deciding whether to work with us or to work with me to really understand exactly what they're getting themselves into. So if I have to take hours, describing what the process is, what is happening, just so there's no surprises in the future, what are the costs, what are, kind of full transparency as to the kind of the nitty and the gritty that maybe some attorneys don't share with their clients because they didn't ask or they think it's not relevant or they'll deal with it in the future. I try to get all that education and empowerment up front. And I think clients appreciate that. I think more and more in this world, we want transparency, regardless of who's providing the service. What are you getting? What am I doing? What's happening? And so I think that's enough. I think a lot about that. I spent an inordinate amount of time happily explaining to potential clients or clients what's going on here, and I think they appreciate that. So I think that's what I think that's what attracts clients to me, for sure. For sure, that's a major reason.
That's excellent. I know the intellectual property information gets very complicated very quickly. So if somebody can explain it in a non-lawyerese way, that's very valuable for people. And you also give presentations all over the world. I assume you're doing them by Zoom now. You used to fly all over the world and do them in person. So you're kind of Gearhart Law's international attorney, right?
Yeah, I give a lot of presentations. There's a full listing on my bio at the website, gearhartlaw.com. And I love it. It's part of the education and empowerment I was talking about. It's not just to other lawyers, it's to entrepreneurs, it's to investors, it's to students, it's to accelerators and incubators all around the world. Yes, everything has been on Zoom, still a busy schedule presenting on Zoom for sure. I don't mind it. It's a little bit more intimate to for some reasons it could be more intimate, but I do miss the traveling and which was always the fun part. So I hope we can get back to that. I hope I can get back to that sooner rather than later, for sure.
Exactly. So what do you think makes Gearhart Law different than other patent, trademark, and copyright firms?
I often say that we're not just about the protection of your intellectual property, whether it's a patent, a trademark, or a copyright, a trade secret, or whatever. We offer so much more. We are really intimately involved with our clients' businesses, the progression of their business, the commercialization of their business, the monetization of their business, the making of their products. So we really pride ourselves on having a network of amazing service providers, amazing contacts, people that really get the entrepreneurial spirit and really share the same thinking that Gearhart Law does. And so we offer that to our clients. It doesn't cost anything to offer that type of service at the end of the day. It's part of the value add of what we offer to our clients. So I think that personal touch of, what your journey is and how to accomplish your journey, that's something we care about and something we're invested in, and something that I think sets us apart from most other firms that may or may not have the time for that, or may not even want to be bothered with that at the end of the day. We bother ourselves with, kind of making our clients happy, for sure.
So if I came to you, well, I have to admit, I did come to you with the fireside idea, and I have a terrible name. You've convinced me to change my name to something that I could trademark, because I couldn't even trademark the other name because I don't know a lot about trademarks. I'm not an attorney. Um, So I guess that was kind of the first step for me with you. But if somebody comes to you and say they have something that is patentable, maybe it's a consumer product, maybe it's an app. I know you do a lot of apps, um, something like that. And they want to start a business. They need a name. They need the patent. They maybe for a consumer product they don't need a whole full blown utility. They just need a design patent. What is the first thing you do?
I think the first thing I do is really get to know what the strategy is, right? What's the end goal here? Do you want to make this yourself? Is this a unique design? How do you want to sell it? Where do you want to sell it? Do you want to bother with branding? Do you want to bother with manufacturing? Do you want to bother with e-commerce? Like that's really part of the story, and that's really part of our advice to a client, right? Like how to proceed, what are the steps, what's essential now, what do you have to do in the immediate, what can we put off for 6 months, can we put off for a year, right? But we really kind of lay out what it take to not just protect the product in one of the forms that you were just speaking about, design, patent, trademark, copyright, whatever, but also what it takes to get the business going. Do you have a partner? Do you have a corporation? Have you been organized? Are you and your partner in a contract together, like a shareholders agreement or an operating agreement? Like, all sorts of, those entrepreneurial pitfalls, we'll call them, or entrepreneurial obstacles that people don't, that often they get smacked in the face with. So why not bring it up in the beginning? So usually my first foray with a client, my first interaction with them is just really getting to know them personally, professionally, and what do they want to do here? That's a big thing, especially if they're coming to me, like you said, from the very beginning. We definitely have clients that come to us. They've already done some of that, and they've already organized themselves, and they've already, have something there, and that's great. But there's a lot of clients that we're the first people that they talk to, so we really want to, hold their hand through that process as much as we can. Yeah.
And how does the pricing work for this? Like, am I going to get hit with a lot of big bills I didn't know were coming?
Yeah, I can't believe I still have to say this, but consultations are free. I'm a big believer in that education and empowerment should be free. Shouldn't charge for that kind of thing. Yeah, you go to college and you pay tuition, but from my perspective, from my education and for your empowerment, for what I'm going to educate you about and empower you about, it's free. But after that, at the end of the day, we're all professionals, and there are services to be provided. Everything, the majority of much of what we do in intellectual property is flat feed. And, a lot of the, tangential counseling that comes along with that is also flat fee. And sooner or later, it's free, but sooner or later it becomes a flat fee, right? So like, for instance, if a client has a question about corporate organization, I'm going to answer it for them for free, right? Sooner or later, they're going to have to start a corporation. That's when the flat fee will, trigger. It's not terribly expensive, these things. I often say that intellectual property is probably the least amount of money you'll spend on in your journey of like commercialization and product development and getting this venture out there. Intellectual property will be a small portion of it, right? You'll spend more in marketing and production and manufacturing. The bad rap is that you have to spend with us first, right? You have to protect yourself before you do all those other things. But because it's flat feed and it's definitely affordable, it's efficient, and it's fortunately it's needed. You need it. It's something. I mean, we can probably spend a whole 3 days speaking about what could happen if you don't protect yourself, and so it's an important expense that has to be considered for sure.
Right. So as the international attorney, if I have something here in the States and I start talking about it, I still have a year to file my patent application. Is that true overseas?
So it depends. There are certain countries in the world that have a requirement that's called absolute novelty, which means that the first and only time that you can ever disclose your idea, and that means talking about it and presenting at competitions and speaking to investors, the first and only time that you can talk about your idea in certain countries that have an absolute novelty requirement is to that country's patent office. And so, people don't know this, and we don't teach this in schools, right? Inventors don't know this. I try to go around the world and teach inventors and entrepreneurs, but like I can't get to everyone. So there definitely are entrepreneurs who have, spoken about their ideas publicly, posted on YouTube, created a website, and you might get in the United States, we'll give you a year from your earliest public disclosure. But you may want to file that patent in another country that has this absolute novelty requirement, and you may be statutorily barred, right, from actually filing in that country, because the first time you were supposed to tell that country was before you publicly disclosed it, wherever you might have disclosed it. So it's important to think about what you're saying, how you're saying, how much you're saying. And it's always important to get yourself on file before you do any of that, regardless of what country. Regardless, you need to get yourself on file before you start talking.
So if I file a patent application in the United States before I start talking about it, will that work to protect me with these other countries?
Yes, 100%. That's exactly what I'm saying, for sure. If you get yourself on file, then if you have a filing date with any country, the United States, we'll take the United States under this hypothetical. You can scream about your idea on top of the largest mountain. I don't care. You can go on all social media channels, right? Your protection is your line in the sand is with the United States. So when you go into other countries internationally in a year or 18 months or something like that, the actual required periods, then you don't have to worry, right? The first time you ever told it was to a patent office, was to the United States. Now I'm going into Europe. And so it kind of your disclosure to the United States kind of grandfathers you into, let's say, Europe, that may have that requirement of absolute novelty. So yeah, always get on file first.
So I've heard that it costs a fortune to file in a number of countries. Is there a way to make that a little cheaper at first till I decide which country I want to file in?
There is. It's called, yes, the governments of the world recognize that problem too, right? So in 1970, they created there's something called the Patent Cooperation Treaty. It's signed by 150 countries. And they said, listen, we know that it's going to be expensive to file in another country. So we're going to create this process that kind of extends the period for you to make the decision and have the money to possibly file in one of those 154 countries. And so you get about a total of like 30 months, 2.5 years. If you follow this process, you get about 30 months from these specific filings. You first file in the United States. A year later, you start the international patent process. 18 months after that, total of 30 months. You then can choose one of these countries. So, I mean, you still have to pay to get into every single country that you want a patent in, but you have 2.5 years, right? And that's a long time. So in 2.5 years, let's hope you've, done something to commercialize, investment, saving, something that you understand which countries I have to file in and what the relevant cost is to file in that country.
So you would recommend trying to, like, let's say I feel like this is going to sell really well in Canada. So you would recommend that I tried selling it that I file this blanket that will get me all the countries, and then I try selling it in Canada before the 30-month deadline. And if it looks like I'm getting some traction there, then I go into Canada and try to actually go through their patent system and get a patent there.
100%. I mean, I wish it was that easy, right? At the end of the day, I love when my clients say, yeah, we're already selling in China and Korea. And so now we're for sure going to file in those countries. Doesn't always happen that way, but yes, that's ideally what you want to happen. Like that's ideally what you should be doing as an entrepreneur, right? You should be concentrating on getting yourself commercialized in the country that you want to file in eventually. And in the background, there's this patent process that's happening. Don't worry about it. We got it covered. You need to worry about getting your product commercialized so that when we come to you with the decision of like, where do you want to file now? You got your extension. It's been 2.5 years, that you can safely say Canada, China. Don't get me wrong. I definitely have clients that are not selling in countries yet but still have to make the decision to think about the country they have to file in. And I often say to them, think about a few things, like in terms of like the decision of where to file. It's a tough one. There's 200 something countries in the world. And so how do you think about this? One, where are you going to have a market? Where are you manufacturing your product? Where do you think you have like a consumer base that loves your type of product, right? Do that kind of research. Think about where there might be the potential for infringement, right? Where does infringement always happen? And do I want to stop it? If I want to stop it, then I should file in that country where I believe infringement of my particular product or service is going to be infringed. So there's a lot of business and economic and legal reasons to choose a country, but it has to happen definitely in a limited time. 2.5 years is a long time, but it's not the longest time.
Excellent. So can you lead me through a process with a client who had a successful outcome?
Yeah, I've had a few actually. Let's talk about who can we talk about? Um, let's talk about Wasteless. Excellent, amazing client. They started in Israel. The Israeli government is amazing. They support innovations in a way that no other country I've seen doesn't. Probably what has put Israel on the map in terms of being startup nation. They basically wanted to solve the problem of food waste, right? You go to a supermarket and you have all those dates on the products, and nobody buys something that's past the date, right? Nobody even buys it when it's a day before the date, right? It's September 24th today. Nobody's buying September 25th, and all that stuff gets thrown out. Like all of it sits in a bin and gets thrown out. And so they created this technology system. It's hardware, it's software that tracks the sell by date of a particular food and puts it on reduced prices for people, or resells them, or indicates to the supermarket like this is coming due, because a lot of times like products don't really have ways to track them, but they put on like RFID codes and sticker, like all types of like devices to track what happens to the food so that it doesn't go to waste and could be consumed by people or resold or sold back to companies, whatever, all of the above. And they piloted in Israel. They then launched in Europe and then launched in the United States. So we help them with their United States patent, their European patent. We help them with their United States trademark, their European trademark. They have filed multiple patents to date. They do very, very well. Major investments as well from different investors. Excellent partnerships with supermarkets, the national chains, European chains. They've been, we've really been with them from the very beginning when they were just two founders. And now they're like this, multinational corporation that does amazing things, and they're constantly innovating. And so it's like, I usually talk to them a few times a month, I would say, on like, different new strategies, new improvements, new patents to file, new trademarks to file, a new slogan came out, a new design of a trademark, stuff like that. Like, one patent grants, let's move on to the next one, that type of thing. Which is what a company should do. So they've been an excellent example of, how to do things the right way, how to position your intellectual property in a way, secure it in a way to gather and garner more investment, right? They didn't make the decision not to pursue IP because they knew how important it was to their overall monetization strategy and their licensing strategy. They're basically licensing this technology to, supermarkets around the world. And so best to have it protected and patented as part of your license agreement, which we help them with as well. So it's, Wasteless.
So they live in Israel. So they filed their first patent application in Israel, but they filed the PCT, Patent Cooperation Treaty, from Israel, which allowed them to go around the world and get patent protection. So how many countries did they get patents in, or did
we have United States, Europe. We're still waiting for Japan, just because Japan takes a little bit longer than Europe and the United States. And I believe we have Korea. Same thing with their trademarks as well. So, just because they've only filed in 3 countries doesn't mean that there won't be more countries for other patents that are in the pipeline. Should their market, like kind of harking back to what you said earlier, maybe their new improvement that they didn't file in Japan, Korea, and Europe, but now want to file in Brazil because that's now their new commercialization country. Oh, great! We have a patent in the pipeline that we could start the PCT process with, or has already been started, and file in Brazil when it's time. So there's a lot of strategy is a never-ending thing for a company, and so we want to be intimately involved in how you're doing and what you're doing it and why.
And they feel that, well, first of all, their trademark is their brand, so that's very important. But they also feel that the patents that they have help them in the licensing process.
Oh, for sure. At the end of the day, they are software company, right? Their trademark is great. They have the domain names and all that kind of stuff, but they are at its core computer scientists. Like there's 3 or 4. There are 3 or 4 founders now, or like C-suites. Can't really call them founders, like CEO, CTO, and they're all computer scientists at the end of the day. And so this is software. This is hardware. They have they created labels for products, and a gun that could like you have in the supermarket, you have that plastic gun that's constantly putting on prices. Well, the gun couldn't help them with their RFID technology. They have to create a gun. You have to create a refrigerator sometimes to store, and some supermarkets don't like the whole point is that you take the product off the shelf and it kind of registers the price, the discounted price, to the point of sale system that's at the front of the store. So all that is like technology. You need to, create new shelving, new refrigerators. They have to retrofit supermarkets and stuff. It's worth it. At the end of the day, it's worth it because all the food waste is money down the toilet. So, they're at the end of the day, they're a software company for sure.
Well, and they're doing something really valuable to society,
Agreed.
world.
Yeah.
I mean, it's awesome. So congratulations for having such a fantastic client and for helping them. Uh, so is there anything else you want to say about your practice or about why people like working with you? Obviously, you've had some very great successes.
Yeah, I just want to say, I definitely split, like you mentioned, I split my time between Israel, New Jersey. I'm on the line pre-COVID, post-COVID. I'm in a different time zone probably than you, but I don't want. I think that now more than ever, I think for sure. But even before COVID, I'm definitely available. That's a big thing to me. I tend to work Sundays. Entrepreneurs love Sundays. I love Sundays. It's great. It takes the pressure off Monday. So I think just availability is a huge thing. Not letting an email go unanswered for 12 hours, like something like that. Yes, it means that I'm on the phone and on the line all the time, but I don't look at it that way. I look at it as providing service that makes people happy. Yeah, I guess that's the way to say it.
Well, yes, here at Gearhart Law in the United States, we kind of have this joke, like nobody can ever figure out when David sleeps.
Very little.
David, it's 1 a.m. his time, he texted me back.
Totally. So I try. If the phone's near me, you're getting a response. Period.
Well, that's important, especially in this day and age. So wonderful, David. Well, I am so excited to have you on Fireside.
Thank you. Thank you for having me. Are you kidding? Thank you.
Yes, thank you.